Well, good morning, everyone, and welcome to this webinar on smoke, mirrors, and legal defences. This is part of a series of webinars from Manolete. On the 22nd of January, our colleague Rachel McCahill will be joined by Alison Morgan, former IP and ICAEW inspector. They're going to do a Q&A session on compliance in connection with claims, and details on that will follow shortly. Today's session is being recorded and it'll be emailed to you all tomorrow, if not today. The webinar today, though, is based on a presentation I gave in September this year at a conference in Reading, and I called it Desperate Defences, and that was my attempt to give it a sort of Hardy-esque flavour. We'll be speaking for about 50 minutes with time for questions at the end. Please use the meeting chat function for any questions, and we'll do our best to get through them at the end. As it says on this first slide, we're looking at defences that might look weak at first sight, but which might not be. The truth is, you can rarely, if ever, be sure to begin with. There's a few things about us. My name's Neil Stewart. My colleague Andrew Murphy has joined me. We're both in Manolete's legal team. I cover the South Coast, Andrew covers Thames Valley, but we overlap a lot. And we work a lot together. Andrew also covers Scotland. The main point of this slide is that we've both been doing this for a long time, both in legal practice and within Manolete. So we've seen our fair share of cock and bull stories, and sometimes they've worked.
Thanks, Neil. So here's an overview on the slide of this session where we look at a range of defences to company and office holder claims. We're going to identify common themes, consider what, if anything, can be done to avoid obviously weak defences wasting your time, talk about how to tackle them when they do arise, and consider what to do if it looks like a weak defence or a try-on turns out to be something you actually need to take seriously. So we've set out the defences on each slide, and we've also paraphrased them in the sort of layman's terms in red in each case as well. There's a list of authorities I can see there available for you in the chat function. They'll be emailed to you with the slides after the session. Now, most of the cases we're talking about are actually mentioned on the slides themselves, but you'll also find the full list and the full citation of each case we mention in that list in the chat function. Yeah, I've just changed to the next slide for Neil to deal with the first offence.
All right, the first offence is, but I took professional advice, which translates to the child in the playground saying, well, he said I could do it. In other words, the Angela Rayner defence, you might say. The example I usually give of this is one of my own cases in which the company director kept saying, I took advice from the company's accountant. Well, when I eventually got hold of the accountant's file, it turned out he had taken advice. Trouble for him was that he'd done the very opposite of what he'd been advised to do. Even where a director does take and follow professional advice, though, that in itself isn't necessarily enough. As in the case of Sharp and Blank, 2019, the judge, Sir Alistair Norris, said this at paragraph 629. In general, a director who takes and then acts upon expert advice has gone a long way to performing his duties with reasonable skill and care. So that's a positive. But the taking and acceptance of advice is not a substitute for the exercise of reasonable skill and care. It is only part of the discharge of that duty. Then at paragraph 630, there are extracts from professional texts, including this. A distinction has to be made between reliance that is merited and blind dependence. And then later, it would also seem necessary for directors to ask appropriate and timely questions of their advisors rather than just accepting everything they are told without question. Now, that issue of when reliance on legal advice is reasonable and when it isn't arose in the slide I've got, the name of the case I've got on the slide there, Wright and others against Chappell. That was the BHS case. The judgment on that runs to 542 pages. All I'll say about it is this. If someone raises it as a defence, ask questions like those on the screen. What instructions did you give? And what information did you provide? Ask for copies, of course. You might find that the director has been selective with what he's told the advisor in order to get the advice he wants to hear. Secondly, who did you instruct? Why, for example, did you ask accountants about a purely legal matter or ask a conveyancing firm about complex tax matters? And then what advice was given? It says, where is it? Again, it's asked for copies. If the advice was to the company and you're the office holder, you're entitled to see it. If it wasn't advice to the company and it's privileged, you can still ask for it. And I'll say more about that in a moment. And then fourthly, fourth question is, what did you do to interrogate or test that advice? And returning to the words of the judge in Sharp and Blank, it may be that the director should have asked appropriate and timely questions. And that applies particularly where the advice is at all surprising or ambiguous, or could be applied in more than one way with different outcomes, or it's caveated, or it's just plain obvious that further questions arise. And that's what happened in Manolete against Nag, or Nag, 2022 case. Part of Mr. Nag's defence was that he'd relied on the advice of Devonshire's solicitors. He said that as honest and competent solicitors, they would have advised him that the transaction in question was improper, and that he was therefore entitled to rely on the absence of such advice. So it would really be more correct to say that he was relying on Devonshire's silence rather than their express advice. And the judge said, it's obviously that much more difficult to justify reliance on solicitors where the defendant did not expressly ask the question and was not given the answer. And then he went on to say, in my judgment, Mr. Nag deliberately refrained from asking because he didn't wish to receive unwelcome advice. And I imagine that most of us have seen that. So the defence can work, but it's seen for what it is. It's just an attempt often to shift the director's responsibilities onto advisors, and those advisors, of course, were not running the company. Now, I said earlier I'd come back to the question of what happens if the advice is protected by privilege. And in Re Travelex, that's the second case I've got on the slide, the respondent sought to rely on legal advice and they eventually produced a 7-page summary of that advice, but they asserted privilege and wouldn't produce the advice itself, even in a redacted form. And that would have been an option, but they, for whatever reason, they didn't do that. Nor crucially did they produce the instructions that led to that advice. In other words, they wanted it both ways, and the judge accepted the applicant's submission that the withholding of those documents meant that it had not been possible properly to stress test the advice given or the questions asked, and not surprisingly, the defendants lost, or the respondents rather lost.
Moving on to the next offence, which is you have no standing to sue or it's nothing to do with you. There's two main ways that this tends to get raised in this context. The first is to attack the IP's appointment, taking an attack, and the second is to attack the assignment. Starting with the attack on the appointment, there's lots of cases on this involving out-of-court administration appointments, and that starts with Minmar and Kalashki in 2011. Now, the appointment in Minmar didn't actually breach the requirements of the insolvency rules, but it did breach a requirement in the company's own articles, rendering it invalid after it was challenged by an agreed director. So following Minmar, there was a raft of cases in which administration appointments were challenged on technical grounds and were sometimes found to be invalid. But we seem to be past all of that now, with a new set of insolvency rules since then, and a more pragmatic approach by the courts. So easy to say, but if you take care to follow the rules and any requirements in the company's articles for the appointment, you should be okay. Now, if there is a defect, you could apply for discretionary relief if there's been a technical breach in the appointment process. If the appointment is actually deemed invalid, then the court can make a retrospective administration order if certain conditions are satisfied, and that's under paragraph 13(2)(a) of Schedule B1 to the Insolvency Act, 1986. Now, if the claims are signed, some defendants look to buy time by challenging the assignment, at least in the pre-action correspondence. This could allege that the assignment document itself is defective, or it could criticise the actual decision to assign. These challenges rarely go beyond pre-action correspondence, but prevention is better than cure. So in the first instance, check the assignment document carefully before you sign it. And also make sure you really think about and record the reason that you've carried out any assignment. Now, during the pre-action stage, it should be possible to correct any technical defects that are identified in the assignment, if necessary, just by doing a fresh assignment if the first one turns out to be invalid or missing some important terms. There's been a series of challenges which have been litigated beyond correspondence. Now, they're listed on the slide there under the attack assignment part. I won't go through them, but the main ones are listed there, and they generally relate to the decision to assign. I'll just reiterate that if you document your decision, your reasons for assigning the claim on the terms that you did, you should be on solid ground because the courts have generally rejected these challenges. At the foot of the slide, there's one more case. We've listed it separately, and that's Hockin and Marsden, because this wasn't a challenge to an assignment. In that case, a group of purported creditors applied for directions to force the company's administrators to assign claims to them. This was against the wishes of the administrators, who didn't want to assign the claim to them, but also didn't want to pursue them on sensible grounds. Of the three heads of claim that the creditors wanted to pursue, the judge only considered one of them to have any merit, but still ordered the assignment of all of the claims anyway because they were so closely linked together. Importantly, though, for our context, it was accepted that office holders shouldn't assign vexatious or frivolous claims that will submit a defendant to harassment from claims with no serious prospect of success. Now, that's quite a high bar. So it's unlikely that somebody will get your assignment set aside on that basis, that it's vexatious or frivolous, the claim is vexatious or frivolous, because you'll have satisfied yourself very early on that the claim isn't vexatious or frivolous. But it's helpful, I think, to understand the court's approach to that sort of challenge. And onto the next slide, next type of defence is a broader category, and this covers ignorance, memory lapses, and lost documents. So roughly translating to I know nothing, and comes up in various forms very often. Now, it can be a very hard defence to pull off where the defendant is a director, and that's because their statutory and common law duties don't really give them the option of ignorance. So let's take a look at those duties. Directors' duties are largely codified in sections 171 to 177 of the Companies Act 2006, but there are others. As Mr. Justice Norris said in Brightonfield and Harrison, which I've included on the slide there, the statutory provisions are not an exhaustive code and do not supplant the common law and equitable principles from which they're derived. So the common law duties which have not been codified include these ones. First is a duty to account for their stewardship of the company's assets so that the director is answerable for any misapplication of those company assets. This is helpful, for example, for claims against directors where assets have been transferred to other parties and it's not practical to pursue those parties, but it is practical to pursue the director. Second is a duty to inform themselves of the company's affairs and to join their co-directors in supervising and controlling those affairs. We've cited Westmid there, but a more recent example is Sittle, Reitharther and Baig in 2017, in which Chief Registrar Briggs, as the position was then called, said at paragraph 35, the standards required of a director to discharge the duties are higher perhaps than at any time in the past. It is not sufficient to simply delegate tasks in a small or medium-sized enterprise. Neither is it sufficient to claim inexperience or lack of knowledge. So each director has a duty to keep themselves informed and can't just leave all supervision and control to their co-directors. The third duty we can talk about, which isn't codified, is the duty to maintain sufficient knowledge and understanding of the company's affairs to enable the director to properly discharge their duties. So here we've referred to Secretary of State for Trade and Industry and Baker. This is one of the cases in the Bearings Group collapse where Mr. Baker, despite his senior position, allowed Nick Leeson to wreak havoc. Now, it's just not an option for a director to sit back and take an inactive role and allow others to make decisions without even scrutinising them, though we see this as a suggested defence quite a lot. If they don't know what's going on because a rogue director is keeping them in the dark, then they still have a duty to at least try and find out. And you have to ask what systems were in place to make sure that the non-rogue directors could learn what was going on. It's also helpful to look at what they could have done, especially collectively, if they were being kept in the dark. For example, could they have removed the rogue director or taken some other steps? They can delegate, but the battleground there is around the phrase delegation to a reasonable extent. Doing nothing at all won't cut it. So as a claimant in these scenarios, you also need to think about causation. What you have to establish is what would have happened if the inactive directors had instead done something to stop or prevent what was going on. And then you have to show that had they done that, the transaction wouldn't have occurred or the conduct would have been stopped. So it sounds very difficult, but the courts have tended to find that any action the directors could have taken in the counterfactual would have actually been effective. So what about when the director just can't remember? Well, similar principles apply here. The director will have difficulty escaping their responsibilities in that way. And if they can't say what happened because the company hasn't kept proper records or they've lost them, then that's their problem. I'll say a bit more on that in a moment, but I've included a warning there on the slide of the danger of delay. Now, this danger isn't just limitation risk, that's an obvious one, but also memories fade over time. So if you wait years and years to bring a claim, a court might have more sympathy for a defendant failing to remember important events. And unfortunately, this in turn gives some defendants a chance to conveniently forget important details when it suits their defence. It also increases the risk of evidence going missing and of witnesses disappearing or just losing interest. And these are all problems that you'll be familiar with. On the upside, as I mentioned earlier, directors cannot escape liability by blaming poor record keeping. The Court of Appeal's judgment in Re Mumtaz in 2011 is helpful in that respect, and we often refer defendants to the following passages in pre-action correspondence when we hear that sort of excuse. So paragraph 16 and 17, the extracts that I think are helpful are: the evidence of the liquidator established a prima facie case, and we need to note those words, and given that the books and papers had been in the custody and control of the respondents to the proceedings, and that's because they were the directors, it was open to the judge to infer that the liquidator's case would have been borne out by those books and papers. And then persons who have conducted the affairs of limited companies with a high degree of informality cannot seek to avoid liability or to be judged by some lower standard than that which applies to other directors simply because the necessary documentation isn't available. Now, those cases have been applied lots since then, including in the two examples given on the slide after Re Mumtaz. So that's very helpful guidance, but you do still need to establish that prima facie case. If you haven't actually identified offending transactions, you can't just say, for example, we think assets are missing, and if the directors had kept proper records, they would show them misapplying them. In our context, the evidential burden only shifts to the defendants once the claimant has identified a transaction. In Brown and Bashir, listed there on the slide in 2021, the liquidators sort of tried to apply Mumtaz in reverse. So the liquidators asked the court to find that large amounts of unpaid VAT, which arose from underdeclared sales, should be repaid by the directors without proving that they actually took and misappropriated the VAT funds. The judge had sympathy with the liquidators in this case because the directors hadn't cooperated and provided them with books and records. Ultimately, though, the judge declined to make that order requiring them to pay the specific sum. Instead, the judge ordered the directors to give an account of their dealings with the company's funds with a view to finding out how much had been misappropriated, if anything. So the Re Mumtaz principle is very useful, but it has its limits, and the prima facie case point is very important.
Moving on to coercion, duress, and undue influence. Well, when are these a good defence and when aren't they? At first, in contract law, duress to the person or economic duress can make the contract voidable. Otherwise, for something like a misfeasance or breach of duty claim, if a director's conduct was coerced, it might negate intent or reduce liability, and it can be relevant where the defendant alleges undue influence or misrepresentation. Where it's not a good defence is where first of all, whether the threat or pressure was lawful, or at least not severe enough to overcome the will of a reasonable person. And I'll come on to that in a moment. And secondly, it's not a good defence if the defendant had a reasonable way to escape or delayed in complaining. So the lesson there is to look for evidence inconsistent with the person not being able to act freely or independently, or evidence that the defendant could have escaped from that position. It might be worth asking, why didn't you resign? Or if they did resign eventually, why didn't you resign earlier? I'll put the case of Royal Bank of Scotland against Ettridge on the slide. It's a landmark case on undue influence in financial transactions. And it's mainly, of course, about what banks must do to protect their own clients from undue influence when, for example, taking security for a loan. It can apply in other contexts, but it's unlikely that undue influence will make any difference in the sort of claims that we all see, unless it turns into coercion. And coercion was one of the strands in Mrs. Harrow's defence in the case of Armstrong and Harrow, also on the slide. That case was mainly about the equity of exoneration, which I'm not going to talk about today, but there were also points about coercion. And the story is that Sandra Harrow and her husband, Christopher Russell, owned a property which they sold not long before Mr. Russell went bankrupt, and the whole of the net proceeds went to Mrs. Harrow. In her witness statement, Mrs. Harrow said that her husband had pressured her into granting certain charges over the property and talked of being, in quotes, persuaded by him. And under cross-examination, she said that forced might have been a better word than persuaded. And the judge referred to her having elevated the term used, which was a clear indication that he wasn't convinced. She also described in her witness statement the sorry state of their marriage, and there's no doubt it was an unhappy marriage. And she said that she now realised that her husband had exercised coercive control over her from the outset. Well, that reminds me of the former Liberal Democrat MP Chris Huhne and his wife Vicky Price. She said that Mr. Huhne had pressured her into taking speeding points on his behalf. Well, it didn't do her much good, because she was sent down for 8 months, same as him, and in a similar way, it didn't do Mrs. Harrow much good either in this case. Because the problem for Mrs. Harrow was not only a lack of evidence on her part, but evidence which ran contrary to her portrayal of herself as someone deprived of the ability to exercise her own free will. For example, there was evidence that, as well as being a co-director with Mrs. Russell of a company, which had received most of the loans, Mrs. Harrow also had a number of business interests of her own. And she was a director of companies that were unconnected with Mr. Russell. So there's her behaving quite independently. And then going in the opposite direction, if she'd really been under Mr. Russell's coercive control, you'd have expected there to have been texts or emails to family or friends about it. But no, there weren't any. Well, I mentioned that if someone alleges coercion, it's a good idea to look for evidence inconsistent with that person being unable to act independently, and that's what you got in this case. And if also, as in this case, the victim says that this was all in the context of a hostile relationship, then it's, again, a good idea to look for evidence that the alleged bully, if that's the right term, did things that can only have benefited the so-called victim. And that, again, is what happened. Well, this was a personal insolvency case. With corporate insolvency claims against directors, they've got a duty under Section 173 of the Companies Act to exercise independent judgment. So they have to clear that hurdle as well, and it's that much more difficult. I'll just round off this slide by saying that if you can interview directors at an early stage, then so much the better. Because if there's no allegation of coercion at that point, it's much less likely to work as a defence later. And that, of course, applies to so many aspects of a defence.
So the next defence we're going to look at is circularity, where someone's arguing that essentially the money you're claiming from them is theirs anyway. So this could arise where the defendants are directors, but they're also creditors of the company. And they will say something like, look, you're chasing me for this money, but it's going to end up coming back to me anyway. So that was the case effectively in the WeCare Community Limited case in 2020, where there was effectively a money go round, if you like. Now, the respondents were the only significant creditors, and there were some other third-party creditor claims, but limited to really quite small amounts. So whilst the respondents were still ordered to pay substantial sums on the claim, ICC Judge Burton limited the recovery to avoid them effectively having to pay monies that would ultimately be returned to them as creditors of the insolvent estate. Now, I think that was obviously very fact specific, so it's not something that is going to hold water very often. For example, in the case of Manolete and Freed in 2024, the respondents there tried to argue along the same lines. But it wasn't a mirror circumstance there, not least because there was an assignment to Manolete in play. So ICC Judge Mullin in that case said that it wasn't clear cut that the respondents would receive any part of the recovery after the funds flowed back to the insolvent estate, and also thought that limiting the recovery in the same way as in WeCare Community would discourage bona fide purchases of claims. So the defence failed and we got our order. So in short, unless the alleged circularity is very clear, that defence probably won't work.
Section 1157 of the Companies Act 2006, statutory defence, and that's where it's honest, reasonable, and ought fairly to be excused, which translates to, well, I did my best. This is the statutory provision that allows a court to grant relief, either completely or in part, and that's in proceedings for negligence, default, breach of duty, or breach of trust against an officer or auditor of the company. The court has that discretion if it appears that the person is or may be liable, but that he or she acted honestly and reasonably, so there's three things here. They acted honestly and reasonably, and that having regard to all the circumstances of the case, that they ought fairly to be excused. Now, usually this is included in a defence as a safety net in case all else fails, and for that reason we don't always take it seriously. Perhaps we should, but I haven't ever seen it appearing as a standalone defence. It's a discretionary power. Occasionally it works in obtaining some relief, but it's difficult to establish because the defendant, as I said, has to satisfy all three requirements: acted honestly, reasonably, and ought fairly to be excused. And if the defendant can do that, you have to ask whether he was actually in breach of duty in the first place. In other words, the two things appear to be mutually exclusive in most cases. Going through the elements, honesty is an objective test. Would a right-minded person, whoever that is, consider this honest? Reasonableness is one of those fluid concepts, but I think we all recognise unreasonable behaviour when we see it, and unfairness is much the same. Another hurdle that the defendant might have to clear is this last one. The court is unlikely to grant relief where the directors have benefited and creditors have been prejudiced. Well, it seems obvious when it's put like that. I've made reference to Humphrey and Humphrey against Bennett and Murphy because it demonstrates that it's not a get-out-of-jail-free card. What had happened there is that Mr. Bennett's counsel had argued that the words "having regard to all the circumstances of the case" meant that the claim had to go to trial when all the circumstances would come out. This was a summary judgment application, and he was saying, well, it has to go to trial, and therefore you can't get summary judgment once Section 1157 is pleaded. But that was the argument put by on behalf of Mr. Bennett. The Court of Appeal saw through it. They rejected the argument and said that the director was unable to avoid summary judgment by the simple expedient of throwing in a reference to Section 1157 in the pleading. The Court of Appeal also spoke of the need to plead specific facts and matters upon which the defendant intends to rely. So it's just the same as any other defence. You've got to specifically plead it. Why exactly should the defendant be excused? And if that's not done, it should fail. As for culpable inactivity cases, it was held in Lexi Holdings and Luckman, the last thing on the slide there, that complete inactivity is by definition unreasonable, and so that rules out Section 1157. So unless there's something unusual about the case and you can see specific facts and circumstances that might persuade a court to grant relief, there probably isn't much to worry about if Section 1157 is simply thrown in. Excuse me. Moving on to the defence novel account, a novel account of events. So you see the defendants coming up with a story which explains everything away, and you just don't believe it. Well, the first thing I'll say is that this tends to work only for defendants in personal insolvency cases, because in corporate cases, it works in both personal insolvency cases and in corporate cases where the claim is against a third party, but not against the director. And that's because if the directors come up with a fanciful story, but don't have evidence to back it up, then they're on a loser. They've got duties to the company, and that changes everything. The novel account of events defence, it's just me. I've now named it that. You won't see it necessarily elsewhere. But I think it's best illustrated by the case of Jessamine and Ali. The simple lesson in this case is that you can't simply write off someone's evidence because he or she is a convicted criminal. And that's not what the liquidators did, but not what the trustees did. And you can't do that even where there's a lack of documentary evidence to support their tale. And in this case, one of the defendants, Mr. Ali, and the defendant's key witness, Mr. Majid, were both convicted criminals. In fact, Mr. Majid gave his evidence from prison by way of video link. A very interesting case. Time doesn't allow me to describe it in detail, but the defence was based on an account of events which, on the face of it, seemed implausible, seemed unbelievable. The key alleged fact which Mr. and Mrs. Ali had to establish was that they'd repaid a sum of 125,000, which had been advanced to them by their witness, Mr. Majid. One of them said that the money had been an interest-free loan from Mr. Majid, and the other, I can't remember which way round it was, but Mr. or Mrs. Ali said that it was an interest-free loan, and the other said it was advanced by Mr. Majid to purchase Mr. Ali's interest in the property, and that was the property he shared with Mrs. Ali. I'll come back to inconsistencies between witnesses' accounts of events a bit later. Mrs. Ali went on to say that she borrowed the money to repay the 125,000 from a company in Dubai. Now, their defence suffered from a lack of documentary evidence, but Mr. and Mrs. Ali were able to provide a loan agreement to evidence the loan, albeit not a professionally drafted agreement. There were problems with that document, and they were unable to provide any other documentary evidence that the loan monies had actually been obtained. Nevertheless, Mrs. Ali said that she borrowed the money in cash in Dubai, took a 10-minute taxi ride to another place in Dubai, and handed the money over to someone in the reception area. They weren't invited upstairs, so there was no evidence of being booked in. Well, that's not their fault if you see it from their perspective, but again, a lack of evidence there. So there in reception, Mrs. Ali handed the money over to a man she hadn't met before, and it was to be paid into an account with a company called DJD International. DJD International didn't provide a receipt, nor did Mrs. Ali ask for one. And neither the Alis nor Mr. Majid were able to provide any documentary evidence that the monies were actually paid to DJD. But Mr. Majid said, well, the money was applied to my ongoing ledger with the company. He didn't provide a copy of the ledger, but that was his evidence. So what we've got there is DJD providing no receipt, no contemporaneous correspondence provided. So the question naturally arose there, well, these were quite complex arrangements, repayment arrangements. There must have been text or WhatsApp messages. Well, yes, there had been, said Mr. Majid, but he went on to say, well, that's my fault. I threw away my phone and I told Mr. and Mrs. Ali to delete all the texts. And I did that, not for this trial, but for my criminal case. Well, I lost that and I'm in prison now, but that's why I did it. And so you got all those positive indications of likely success, but the trustee's application failed, and it failed entirely. In fact, the judge was critical of the trustees for having declined to interview Mr. Majid beforehand, and said they were hardly in a position to complain if they learned of some details only at trial, which was a problem they had at trial. Well, that looks harsh, but you might say they should have interviewed him. Well, hindsight is a wonderful thing. What's the takeaway from all this? Well, I'm not going to make some crass comment about what the trustees in bankruptcy might have done differently, not least because I think I would have done exactly the same. What I will say is that where the defendants don't owe any duties which require them to keep proper records, it can be much more difficult to rebut their defence. And their documentary evidence might be really thin, as in this case, they just had a homemade type loan agreement. But don't forget, the crucial point is that their oral testimony is evidence. We sometimes hear people say they've got no evidence of that, but that's wrong. If whoever is making that assertion, or telling the story, is prepared to make a witness statement, sign with a statement of truth, and or give sworn oral testimony in court. And there's a couple of other things on the evidence of defendants. I mentioned inconsistencies between the evidence of witnesses. Do look for and exploit any inconsistencies in their evidence, but the important thing is not to assume that those inconsistencies will necessarily undermine their defence. And that's because if all the defence witnesses come up with exactly the same story, it smacks of collusion. The odd inconsistency here and there gives it a ring of authenticity. And that, I think, was probably partly why the judge, who's by no means naive, believed the defendant's fairly detailed account of events. And as I put at the bottom of the slide, just because a witness lies about one thing, it doesn't mean that he or she is lying about another. That's a fascinating area, but we don't have time, so I'll leave it there.
So the rule in Ex Parte James is next, and that comes from Recondon and Ex Parte James, 1803, so a very old case. This is all about office holder conduct and is sometimes used to challenge their decisions in administering the insolvent estate. But it can also be used as a defence to an office holder's claim, and of course an assignee's. So it goes back to the early 19th century, and the modern way of putting the rule is this: a court-appointed officer administering an insolvent estate must not insist on the strict legal rights of the estate where this would result in an enrichment of the estate contrary to the dictates of fairness or natural justice. So it's where the office holder is behaving perfectly lawfully, but the court says it's just not cricket. I've only ever seen this raised in pre-action correspondence, and I've never seen it pleaded in a defence. And it seems a bit desperate these days for two reasons. So firstly, the office holder wouldn't have brought the case if it was unfair or unconscionable, and nor would an assignee. Secondly, the law has moved on. We've got other ways of dealing with unfairness, such as Section 1157 of the Companies Act, as Neil's been through, and the discretionary nature of remedies under certain statutory provisions, which Neil will deal with in the next slide with a few examples. So the principle is quite hard to apply to the sort of insolvency claims we're thinking about here. Now, it did feature in the case mentioned there, Lehman Brothers and McNamara, which is a Court of Appeal decision in 2020, but that related to contractual dealings by the company's administrators. The Court of Appeal decision did clarify, though, that the correct test to justify interfering with the office holder's actions under this rule is unfairness, not the wider concept of unconscionability, which had been held at first instance. Sorry, it's wider than the concept of unconscionability. And that was then followed in the case of HMRC and Sanders. So that's all very well, but how would a director, for example, use it to defend a breach of duty claim? Well, remembering that the correct test is now one of unfairness, I can see how a director who is also a major creditor might think it unfair that they've propped up the company for years financially and now are being pursued for a preference and breach of duty claim where all they've done is paid themselves back just some of the money the company owes them. Now, the problem for the director in those circumstances is that if you can actually tick all of the boxes for that claim to have merit, then you've effectively shown that their actions were unfair to the general body of creditors. So they've then got an uphill task in persuading the court that, in the alternative, the claim is unfair to them, which takes us neatly on to the next slide.
Yeah, justice and equity. We've chosen in this case to illustrate the point, Bucknell and Roach against Wilson 2020. This was a preference claim by the trustees in bankruptcy of Peter Folds against his stepdaughter, Gina Wilson. Mr. Folds had paid Gina Wilson £47,675 in part satisfaction of some invoices for accounting services, for accountancy services rather. The bankrupt had also paid off all his other creditors, bar one, but none of those other creditors were connected, so the review period was only 6 months as opposed to 2 years for Ms. Wilson. So the payment to her was caught, the others weren't. The only other creditor he didn't pay was his son, Mark Folds. Mark had successfully sued him, was now owed over £700,000. So this was a kind of reverse preference, as it were. The bankrupt was happy to pay anyone as long as they weren't Mark Folds. The judge at first instance accepted that the claim had been made out. All the boxes were ticked, but he was troubled by what Ms. Wilson told him. She said she'd used the money to repay a debt to her father. Her father had fallen on hard times, she said, and he needed the money to pay for his wife's cancer treatment. So she couldn't get it back. And if she now had to repay the 47,000 from her own resources, she'd have to sell a house and move to a less desirable area, which would be bad for her and her children. Now, the judge said that that amounted to a change of position, and he referred to section 340, subsection 2 of the Insolvency Act, which says, the court shall make such order as it thinks fit for restoring the position to what it should have been if that individual had not given that preference. He said that established a discretionary power, and that extends to making no order at all, as established in Re Paramount Airways Limited. It's a 1993 case. And he said it would be unfair on Ms. Wilson to make an order, so I'm not going to. Well, not surprisingly, the trustees in bankruptcy appealed, and the appeal judge said, well, yes, the change of position wasn't as strong a factor as the trial judge considered it to be, but he nevertheless upheld the decision to grant no relief. And he did so on 4 grounds, one of which was that Ms. Wilson no longer had the money, and the impact on her of having to restore the payment would be wholly disproportionate to the benefit to the estate. Now, there are many features of the case that call for comment, but I'll limit myself to 2. The first one is this. Strange as it may seem, you can't always rely on the wording of a statute. Section 340, subsection 2 says shall, that the court shall make such order, not may or shall if it feels like it. It may shall make such order as it thinks fit for restoring the position. And I picked out those words for the slide because I can't see how making no order at all restores the position. And you can push an analogy too far, but isn't that like stepping into a cab and saying to the taxi driver, I don't care how you get there, but I need to get to Waterloo Station. And the driver says, well, if you don't care how I get there, then I won't go anywhere. And by the way, if you've seen that before, I've used it before. I've not stolen it from somewhere. And then secondly, even if you can tick all the boxes for a claim, it might just be worth pausing in a case like this and asking yourself, where will the sympathy of the court lie? Because if it's with the defendant, the judge might well find a way of letting them off the hook. Moving on to a technicality or to technicalities, this is one that can trip you up, and that there isn't much that you can do other than make sure that you've got first-rate counsel to argue your case. This does strike me a bit of, a bit like Bill Clinton arguing, well, it depends on what the meaning of is, and he's still got away with it. But the case I've chosen is Darton against Jeff Carton Kelly. This is the Comet litigation. I'm going to skip over it a little bit, but the background is that CGL Realisations Limited, formerly the Comet Group Limited, had entered into a complex series of transactions, which I'll simplify. On 9th of November 2011, Comet's parent company's parent, Keza Electricals plc, entered into a sale and purchase agreement to sell Comet to Op Capita LLP. And on completion, the SPA required Comet, which hadn't been a party to the SPA itself, to enter a completion agreement, requiring it to pay an unsecured £115 million intra-group debt to KESA, which it did. And the judge at first instance found that the repayment amounted to an actionable preference and ordered the £115 million to be repaid. Now, there was an appeal. Darty Holdings SAS, which had acquired the assets and liabilities of KESA, appealed. And Darty, I should say, had already tried to use a timing point to quash the claim. Pre-trial, they'd argued as a preliminary point that Comet and KESA International were no longer connected by the time of the payment of the £115 million. And that was a result of Comet shares having already been transferred by that time under the SPA. And as they were no longer connected, they said, the statutory presumption of a desire to prefer didn't apply. Well, that was a weak technical point, you might think, and Deputy ICC Judge Raquel Agnello KC thought so as well and dismissed Darty's application. But they tried again in the Court of Appeal. It was a similar timing point, but they said this time, OK, the old board did want to prefer KESA, granted, but the final decision to pay the £115 million was made at a board meeting on the 9th of February 2012, not by the old board, but by the complete new board at Comet. And that new board had no desire to prefer KESA. Their desire, said Darty, was only to action the completion conditions of the SPA. And the Court of Appeal agreed. The operative decision, it said, was taken on the 9th of February 2012, not by the old board when the company entered the SPA 3 months earlier in November 2011. So the operative decision, where did that term come from? And to me, it looks a bit like splitting hairs. Well, no, it doesn't look a bit like. It looks like splitting hairs. The old board of Comet clearly wanted to prefer KESA, and everything was put in place for that to happen. And the new board pushed the button. And I could say that the lesson to be drawn is that you must carefully consider not just the timing of the preference, but also when the operative decision took place and who made that decision. But actually, I don't think that's the main lesson. I think the main or a more general lesson is that the case turned on what might have appeared at the outset to have been a fine, even an artificial point. And therefore, when you're contemplating litigation, you can't afford to ignore or assume anything.
So, having been through all that, let's summarise what we think you can do to preempt or avoid these types of defences getting very far. Firstly, appointments and assignments, make sure they're watertight, because you want to get on with administering the estate or advancing the assigned claim. But prevention is better and cheaper than cure. So spend the time getting the assignment document right at the outset and record your reasons for any assignment. Secondly, with claims against directors, you often have the benefit of being able to interview them, and that's your chance to get their story. So even if you doubt what you're being told, it's their version of events, and you can refer them back to it if they change their story later, reducing their credibility as a witness if it's inconsistent. So if they ignore requests for interviews or written questions, then that won't do them any favours either. Thirdly, documentary evidence is key, as we've spoken before about the difficulties with human memory over time. The courts tend to prefer documentary evidence where there's a conflict, particularly contemporaneous documentary evidence created by an independent third party, because they've got no reason to record anything inaccurately. So gather this early. Fourthly, evidence preservation is vital, particularly the company's books and records obtained from third parties. Office holders want to avoid a director trying their luck with the "I gave it all to you, so you must have lost it" line. So prepare an inventory of the documents you receive as soon as you get them, and keep a record of where any physical papers go if you release them to anyone. The same goes for receiving electronic files. Record what you've received, when you received it, and who sent them to you. Fifthly, delay can be fatal for the reasons we discussed. This isn't just about limitation. Memories fade over time, and witnesses and evidence go missing. So how can we, what are some practical steps we can do with to tackle these issues? Well, Number one, take steps to rectify any appointment or assignment defects where possible, as early as possible. Often these can be fixed quite simply retrospectively, and if they can't be done of your own volition, then they can be done with the court's assistance. Secondly, further detail. So even if you don't think much of a defence initially, perhaps from an unrepresented defendant who can't set it out very clearly, you still need to gather as much information as possible early on whilst they're corresponding with you. Ask questions and request supporting documents. If they refuse but produce them later, it really raises questions that are to your benefit. Third, identify and explore inconsistencies in the defence. So you might think it worth keeping these up your sleeve for some sort of big reveal later on in the litigation. I'm not so keen. I don't think many people are. I'd rather point this out early, because if there's an explanation and the entire claim falls away because of it, then I'd rather know that early on. And if the other side can't explain the inconsistency, then they're more likely to think about settlement early on. Fourthly, seek evidence from third parties, such as the ones listed on the slide there, accountants, employees, and customers, before they forget or before they disappear or documents disappear. If these people are truly independent, like those listed on the slide, you'll very likely get the truth from them. And fifthly, have a think about what is obviously missing, whether that's a document or witness evidence from someone who is clearly involved. These days, it's likely to be electronic communications. So we've likened this to the dog that didn't bark in the Sherlock Holmes adventure of Silver Blaze, because Holmes thought it there that it was a curious incident that the stable dog didn't bark when someone stole a horse from the stable at night. The bark was missing, if you like, because dogs tend to bark at real intruders. So in this case, the intruder couldn't have been a stranger. So where an aspect of the defence cries out for some missing evidence or a witness that the defendant doesn't produce, then dig deeper to find out why, or at least to satisfy yourself that they won't be able to prove this point later on.
I'm aware that we're running over time, so I'll whiz through this last slide. What happens if the defendant comes up with something that looks like a try-on, but it turns out to be something that you should take seriously? First of all, do you plough on regardless? Well, that's okay if you remain confident, but do consider these things if it changes your view on the merits. First of all, the effect on any ATE insurance you might have. You don't have to worry about that if you're with Manolete, because we don't use it. The possible judicial sanction if pre-action you're on notice of a complete defence, but you issue anyway without first investigating it, and then possible adverse cost consequences if you get it wrong. And more positively, you might want to consider whether there's anything you can do to bolster your claim, such as asking customers, where a director claims to have been kept in the dark. Well, who did you normally deal with? And secondly, amendment to pleadings. I'll gloss over it. I'll put pros and cons. It's try and avoid it if you can. If you must, try and do it only once. Thirdly, reevaluate. Natural reaction when you receive something that threatens to derail your claim is to leap into action, shore it all up, and look at how to defeat the defence. And that's all fine, but before you do all that, it's worth pausing and reevaluating the claim. And it might be a good idea to ask a colleague to look at it, because a fresh pair of eyes can offer a different perspective. Fourthly, review any Part 36 offer you've made. Consider whether the new information merits making another. I put timing and preparation because it's a dead giveaway if you've changed your view on the merits, but I think normally it's just best to get on with it. If you're going to make a fresh one, just make it with minimal explanation. And finally, a note there about negotiation and alternative dispute resolution. We get great results through mediation, and that was both our experience. That's been our experience in Manolete, and Andrew and I always used to find that in private practice as well. This is worth remembering. It can be done at any stage of the process, and we've been surprised at how effective and relatively hassle-free a half-day virtual mediation can be, but that's a whole new subject. Just before I move on to questions, I need to let you know that we'll be sending a feedback link. If you could complete that, please, it will help our future sessions. But I'm looking down now to, have you seen any defences where the defendant has clearly used AI? Yeah, we were talking about one yesterday. clearly used AI, and are these more difficult to deal with, i.e. lengthy pleadings, incorrect case references, etc.? Well, in fact, the incorrect case references is fairly easy to deal with because you say, well, this is a made-up case. This is a hallucination or whatever by the AI. Um, uh, yes, we're bound to get more and more of this, and if it hasn't been used intelligently, I would say that it doesn't really threaten very much at all because you get a fairly bland response, and sometimes you have stuff thrown in which is completely irrelevant. How about you, Andrew? Do you find have you had many?
Yes, absolutely. You've got one on the desk at the minute, actually, and we see more of it these days, as Neil said. It's not something really that concerns us because the ones I've seen are just bad defences, but longer than they would be from a litigant in person without any assistance. That this sort of it starts with pre-action correspondence. You have very, very long letters asking rafts of questions that they don't really need the answers to, and sort of getting the law wrong for the vast point. So it can increase costs a little because our external solicitors, of course, need to spend a bit longer replying to these things. But frankly, once you've actually issued proceedings, it doesn't cause that much inconvenience because if they stick with that sort of ChatGPT or whatever they use model, it is still just a bad defense. ChatGPT cannot plead things compliant with the relevant procedural rules for the court. So if they're not pleading things properly and not actually setting out a cogent defense, then it exposes them to the risk of us obtaining summary judgment, for example. So it's not really posing a huge problem. I suspect sometimes the prompts that they give to ChatGPT or whatever they're using is something like, please respond to this with as long as in as many words as possible, raising as many questions as possible, and referring to as much case law as possible. And it's very rarely effective from what I've seen.
It's still very much the garbage in, garbage out. If you're putting in, well, this is my defence, and it doesn't really amount to a defence, then it's going to struggle. But just moving on to the next one. It's not really a question. It's thanks for the mediation plug. Well, very happy to do that, Carolyn. We use it for a lot of our cases, as I say. I know you use it frequently with good results. We do, and there's many ways of doing it, and we'll carry on we'll carry on using it for as long as I can see. I'm looking down. Amber, are there any other questions? I can't see any on the chat. We're now at 10:59.
No.
No, great. Well, I think that's a good place then to draw a line. Remember the one on the 22nd of January with Rachel and with Alison Morgan. And until then, goodbye and thank you for joining us.
Yes, thanks all.